Today's question is, lawyers of Reddit, what was the best gotcha moment you ever experienced?
I acted for a plumber who ripped up a tile floor to replace a pipe. He installed new tile on top but warned the owners not to walk on it for 48 hours. He emphasized not to let their kids or their dogs walk on it either. They walked on it but alleged the defects were caused by improper install. We had an expert do a report which confirmed that it was consistent with proper installation but people walking on it too soon. Crazy homeowners still went to trial on it. In their evidence disclosure, they included a series of pictures. One of the pictures had in the foreground a tile that was tilted upwards. The background very clearly showed a dog's paw pressing down on the other end of the tile. That wasn't so much an I got them situation as they got themselves. I had a client whose $60K car was ruined by a shop that put in the wrong oil. We couldn't prove it at first. The engine blew up, oil leaked out, and evidence was lost. I subpoenaed their bank records, figured out they bought their oil from Costco, called Costco, and got to their prices for the last 2 years. I then worked out the amounts they were spending, did some backhand math, and showed based on the values it was impossible they had ever bought the right oil. They settled in full immediately. Told this story a few years back, but everything old is new again. My brother is a divorce attorney. His most memorable case, he was representing a guy in a divorce custody battle who was accused of horrific child abuse. Very graphic, very detailed depositions from the young kids against daddy. Things look grim. Then my brother notices the deposition transcript, done by social workers under oath, contains a question at the end from one of the kids. Did I hit my marks? My brother had previously tried to make it as an actor in Hollywood right out of high school, failing miserably, and decided to go into law, an altogether different form of acting. He wonders how little kids know about acting jargon. Subpoenas the wife's personal checking ACCT during discovery. Sure enough, acting lessons. Deposes an extremely sketchy acting coach, and panicked coach quickly coughs up DVDs of practice interrogations with the kids, hours of coaching the kids on exactly what imaginary things to say about daddy. He says it was his one and only Perry Mason moment in 20-plus years of practice, and dad got sole custody of the kids. I was representing mom in a bitter custody fight. Dad wanted full custody and argued mom was an unfit parent. Mom wanted full custody because dad had a history of domestic violence towards her and the kids. Dad's lawyer was doing a good job of painting her in a bad light during his cross-examination, and I was starting to get worried. His lawyer brought a close family friend as a character witness for dad, who said the usual nice things about dad. Then he said something about them owning chickens. I thought that was odd, so I asked more questions. I was able to get the friend to spill the beans that the dad owned chickens for illegal cockfighting, and he'd take his minor children to these cockfights, and when the children were acting up, he'd punish them by forcing them to feed the chickens, during which they would get pecked and scratched by the chickens. And obviously, the children were terrified of those chickens. I could see the color draining from dad's lawyer's face. Mom got full custody. This is so petty. I've had much bigger moments, but because of the character of the other side, this will always be my favorite. Doing a boundary dispute, a squabble over what was essentially a few inches of land. OS was a lawyer and an absolute arsehole. He was acting for himself. The whole, a lawyer who acts for himself has a fool for a client, thing was bang on for him. But he was a deeply unpleasant guy, a bully who thought that he was the smartest guy in the room. Part of his case hinged on wheelie bins and how prior to the boundary having been moved there wasn't space to store a full-size bin beside the house. The fact you now could meant clearly the boundary must have moved. That was the extent of his evidence. It really was thin stuff. During the actual trial he pulled a fast one by suddenly producing an old aerial photo ostensibly to show the boundary at the front of the property had also moved. A fast one because you have to disclose stuff like that in advance. You can't just sit on something relevant and then suddenly whip it out at trial with a flourish. Whilst he was making his submissions that it should be admissible, I looked more closely at it. Away from the bit of the boundary he said it was relevant to and realized that it very clearly showed a wheelie bin in exactly the spot his case said there couldn't be one. told the judge we were happy for the photo be admitted after all, got the other side to confirm the date it was taken, then pointed out he just completely fucked his case. That photo did him for nearly $50K in adverse costs. Couldn't happen to a more deserving chap. This isn't sexy, but the criminal defense guys will like it. Client, a fry cook, has a DWI pending. The police agency, somewhat unbelievably, refuses to provide Brady material to the DA, which has a duty under the Constitution to hand it to me. Brady material, briefly, is information in the possession of the state which would tend to exculpate or mitigate the charge against the defendant. In the U.S., we all have that right. The DA more or less abdicated his duty to seek and provide it, and suggested to local defense attorneys that they subpoena the chief of police at the agency, which is a university police department. I didn't think that was such a hot idea, so I subpoenaed the president of the university. Well, that made some folks a little crazy, including the Texas Attorney General's office. The AG filed a motion to quash my subpoena, citing how busy the president was and how she can't be troubled with routine clerical matters. The court was not impressed with the motion to quash. Characterizing denial of due process as routine and clerical didn't do what the AG thought it would do. On the day of trial announcements for the following week, an attorney from the AG's office appeared in response to the subpoena to get his motion to quash granted. Before anything happened, he came up to me and asked with maximum smugness, "You really think you're going to get what you came for?" I smiled. When the judge asked if I was ready for trial, I said no. The state had not provided constitutionally mandated material, so I can't try the case yet. I asked the court to call my witness, the president of the university. The court nods at the bailiff, and the bailiff starts walking toward the door to call for the witness. Then the smug AG steps up and tells the judge that she's not coming, but he's here to get his motion granted. The judge gives him one of those nice judicial eyebrows and looks at me. "I need my witness, Judge. There's bad faith and unconstitutional shenanigans afoot, and my client needs the protection of this court from the executive branch." The judge seemed to agree with me and looked at the AG, who had expected to get what he wanted by virtue of his office and his truly nice suit and enviable haircut. The AG says, "Well, she's not here, but I did bring the police chief." A woman of about 40 comes and wearing a police chief's uniform. The AG introduces her to the court. She starts talking about Brady material. I object. "Hey, Judge, this is a criminal proceeding. Can we have the witness sworn?" "Yes, we can." He swears in the chief. She starts talking again. I object. "Hey, Judge, this is a criminal proceeding. Can we have questions and answers?" It means that a lawyer sponsoring a witness has to elicit testimony through questions and answers. Sustained. Then the handsome, well-dressed, well-coiffed AG went blank. He had not planned for this. He didn't know what Brady material is. He had not talked with his witness before appearing. He had never taken part in a criminal proceeding before. He said out loud, "I've never been in a criminal proceeding before," and looked to the judge for help. But all he got was another judicial eyebrow. The chief is just standing there. The AG finally asks her, "Have you provided all the Brady material to the DA?" She says, "Yes." That was his only question. Now it was my turn. Now, every lawyer in my county is pissed at this police agency over this Brady issue, including the judge and the DA. Me. "Good morning, Chief. Can you tell the court what Brady material is?" Chief. "Yes, it's sustained written complaints against the officers involved in the case." Judge. "No, it isn't. It's anything." Me. "Judge, please don't give her the answers." Judge. "Sorry." Me. "Is there anything else that might constitute Brady material?" Chief. "No." She is so wrong that even the clerks and bailiffs are rolling their eyes. I won't trouble this comment with the whole transcript, but she did go on to swear, under oath, that she had provided all Brady material to the DA over a month ago. Now, this is only a misdemeanor matter, but the elected DA and his first assistant are in the courtroom to see how this goes. Hearing the chief make this statement, the first assistant steps up to the bench and asks the court if we might not have a little break. Judge says sure, maybe I'll need to talk. The chief, the AG, the DA, and the first assistant all go into the DA's office to chat. I twiddle my thumbs for a while. When they're done, the AG comes up and says, "Hey, we have an agreement with the DA now. Will you withdraw your subpoena?" I said, "You've been negotiating with the wrong party. The DA is my opponent, and your deal with them means nothing to me. Let's get your witness back into the courtroom." He says, "That's bullshit." I say, "We're swearing now? Cool. Go fuck yourself." Back in the courtroom, the chief is going to testify some more. She now swears, under oath, that only yesterday she had learned of the existence of internal affairs files which might have the names of my officers on them. No, she hadn't known about them before yesterday. Yes, she did know about them when she swore in court that she had already given everything over. That, my friends, is aggravated perjury with the intent to deprive my fry cook of his legal rights. And that's what the AUSA will think when I finish this case and send her the transcripts. The very idea that a police chief would say under oath that she did not know about her own internal affairs division, which would be the first stop on any chief's first day at work, is laughable. Frankly, this woman was in way over her head. But she fully expected the court to accept her lame excuses and false claims and go ahead and screw my fry cook. The trial is postponed and still hasn't happened. The DA asked the court to take documents for review in camera to determine what is and isn't Brady. I objected. That was the DA's duty. The court is busy enough without having to do the executive branch's job. The court thought this was pretty good. In the end, the court accepted the documents after I demanded the DA waive any objection to my reviewing them with the court. After all, the court doesn't know what might be Brady without knowing all the facts. I had the court acknowledge then that, within the documents provided, anything that I want is Brady. If I want it, it must be Brady. If I don't, it isn't. That should be the legal standard everywhere all the time. But at least for now it's the standard in this case. Also, the subpoena was not quashed, and the president is still on the hook to appear next time. The court wants to hear from her why the state-funded university doesn't have to comply with the Constitution. And I am not satisfied that the documents provided are exhaustive, so we'll keep hammering at this police agency until something breaks off. Edit. I forgot to tell you that during the first session the judge specifically called on the AG guy to stake his bar card on the proposition that all the Brady material had already been provided. The AG guy bravely did so, not having any idea what Brady material was. At that point the judge looked at me and said, "Now are you ready?" He just wanted that guy's ass. I had to say no. I was happy to see this lawyer disbarred, but I was still worried about my guy getting a fair trial. So while it's nice that this guy might lose his ticket, we're not done yet. I'm leaving that part to the court. I want the chief. And this is the end of today's video. I hope you liked it, and don't forget to comment an anecdote or experience similar to the topic of the video. Leave your like, share if you liked the video, and lastly, don't forget to activate the little bell so you don't miss any of our daily videos. Bye-bye.